Thank you, Mr. Chairman. Ms. Abelson, welcome. It's great to have you here. Congratulations on your nomination. Let me just pick up on a question that Senator Blumenthal was asking a moment ago about abortion and life issues. What standards should courts apply when reviewing state abortion laws?
What the court held in Dobbs was that the Constitution doesn't say anything about, does not provide a right to abortion. And as a result, Dobbs returned the issue of abortion to the people and the representatives state by state, and said essentially this is not a question for federal judges because it doesn't say it in the Constitution. It's a question for the people in the democratic process. And that is the effect of Dobbs. And as a result, the state democratic process is now the process that has control over that issue.
What about federal legislation affecting abortion?
Federal legislation affecting abortion would be subject to the same, scrutiny as other federal legislation. It has to fall within Congress's enumerated powers, first and foremost.
What's the precedent or lines of precedent that would govern any review of federal legislation related to abortion?
Well, I mean, a few lines of precedent might potentially be relevant. Whether it's legitimate commerce clause or spending clause legislation is probably the first question that comes to mind, depending on how the law is structured. And if not, whether there is some other, affirmative hook in the Constitution that provides Congress with the power to pass that law.
So you recognize Dobbs then as the controlling precedent when it comes to life questions. Is that what I'm hearing you to say?
From the Supreme Court, yes,
yeah.
Senator.
And the Seventh Circuit or anywhere else for that matter, correct?
Absolutely.
I mean, if there's any contrary Seventh Circuit precedent, Dobbs would supersede that.
Absolutely.
And I'm sorry, go ahead.
No, absolutely. And I would faithfully follow Dobbs.
Good. And you regard it as controlling precedent and as settled law?
Yes.
Let me ask you this. How should courts weigh the rights of medical providers who object on conscience grounds to participating in abortions?
The Supreme Court's decision in Hobby Lobby reflected the fact that employers have important religious rights to, resist the government's requirements that they provide certain forms of health care to which they object.
What about doctors?
I'm sorry, Senator. What about doctors?
Yeah, medical providers. I mean, doctors who object to participating in abortion-related procedures.
Well,
how should a court weigh those claims?
I think I should be somewhat circumspect because there is, litigation pending around the country, and so the canons of ethics preclude me from prejudging these questions too much. But I think the basic method of analysis would follow the Supreme Court's approach in Hobby Lobby, but extending it to that context.
What about pro-life sidewalk counseling outside of clinics? Is that core First Amendment speech?
Sidewalks are recognized by the Supreme Court as core, public fora where the rights to free speech are at their zenith, or at their strongest.
And there's no difference. It doesn't matter if it's an abortion clinic or something else you're saying. I mean, regardless, the fact that the sidewalk is a traditional public forum should control the analysis, whatever the facts of the case may be.
Yeah. Generally, Senator, under Supreme Court precedent, content or viewpoint-based discrimination in the context of a traditional public forum is viewed with extreme skepticism.
Very good. Let me ask you about free exercise questions. Should the free exercise clause be given the same strength and weight of other fundamental rights like free speech?
Absolutely. The free exercise clause, I believe, the very first clause in our Bill of Rights, for a reason.
So it is. How should courts evaluate claims of religious liberty when they conflict with generally applicable laws?
The Supreme Court has spoken to that recently in cases like 303 Creative, and some other, Espinoza, Fulton. And what the Supreme Court has established is that even generally applicable laws don't carry with them an exception to the First Amendment's free exercise clause. And so if the application of what looks like a generally applicable law, like let's say a funding restriction, has the effect of discriminating against people for their religious practice, then that can violate the First Amendment.
Does the Trinity Lutheran case have any bearing here, do you think?
Yes, thank you, Senator. The Trinity Lutheran case concerned, if memory serves, funding for those playground grounds. We've all seen them with kids that are made of, recycled tires.
Correct.
And there was a state program to fund playground grounds of recycled tires. And a church playground, applied for funding, and it was denied on the grounds that, we don't provide funding to church organizations. And so what the Supreme Court held in Trinity Lutheran was, no, you can't do that. if you have a general funding program, you can't discriminate against some of your recipients simply because of their religious faith.
And how does that interact with the Smith case?
The Smith case held that general laws of, I think, neutral applicability don't necessarily violate the free exercise clause, and Smith remains a precedent of the Supreme Court that I would follow. But in the last, 12-ish years, the Supreme Court has explained that Smith doesn't mean a state can effectively exempt a religious entity from a state benefit, which is what was happening in cases like Trinity Lutheran.
Yeah, last question, Mr. Chairman. I think you're Mr. Chairman now, right? Yeah, very good. Just one further question on Smith. So in the Trinity Lutheran case and the Hosanna Tabor case, the Supreme Court said, well, Smith actually is about physical acts. It's not about other things. How do you understand that? I'm not asking you to grade the court. I'm not asking you to go beyond what the court said. I'm just trying to figure out how you're a student of the law. You've worked at that court. You've litigated at that court. I'm just trying to figure out how would you as a judge, you're going to have to read these intersecting lines of cases. What does that mean to you? How do you interpret that? That distinguishing of Smith, what do you think that means? How does that cash out?
That's a tough question, Senator. I think the Supreme Court is, struggling with Smith in many of these religion cases. I think, the other thing that it said in City of Fulton against Philadelphia was that Smith didn't apply there because although there was a general policy, it was one that the city was granting exemptions to, sort of left and right. And so there are certainly exceptions to Smith that the court has recognized. But happily, there are enough of these cases that I think as a lower court judge, you can generally find one that's roughly similar to the facts before you. And that's particularly true in the last 12 or 13 years, where these cases have been uniformly protective of religious liberty. So my essential method would be one of analogy and, to see which of these Supreme Court cases is most on all fours with the case before me.
Thank you very much. Thank you. I've enjoyed your answers and I think very, very cogent. Thank you very much. Thank you, Mr. Chairman.